To see you. Would you like to reserve any time for rebuttal, sir?
I would, please, Your Honor. 3 minutes for rebuttal.
All right, thank you, sir. You may begin.
Good afternoon, Your Honors. May it please the Court. My name is Tyler Cavanis, here on behalf of the appellant, Jennifer Sexton, here from the Knoxville Bar. Ms. Sexton was convicted at trial here in Knox County of vehicular homicide by recklessness, felony, filing a false report, following too closely, and then driving on a suspended license. And so in my opening brief, I raised issues related to the admission of expert testimony related to the vehicular homicide charge, and then the jury instructions on the false report charge, and also the following too closely charge. I'd like to spend my time today focusing on the admission of the expert testimony issue. Of course, happy to answer questions related to the other issues. But this was a vehicular homicide by recklessness charge. So there was no intoxication alleged. That was not an issue at trial. And this was a situation where early in the morning, around 5 a.m., traveling on Interstate 40, there were not many vehicles on the road. It was a poorly lit stretch of highway. Ms. Sexton, it was not debated that Ms. Sexton rear-ended a motorcyclist. The motorcyclist was ultimately thrown from the motorcycle and then killed. He was struck by another vehicle on the roadway. It was unclear whether leaving the motorcycle is what killed him or being struck by another motorcycle, but there was certainly a clear chain of events from the rear-ending to being thrown off the motorcycle and then killed. A significant issue, perhaps the most significant issue at trial, was the speed at which Ms. Sexton was traveling at the time that she impacted the motorcycle. I think it was undisputed that it was a dark night. The motorcyclist was wearing dark clothing, and he was only illuminated by a single tail light on the rear of his motorcycle. And so there was an issue about the environment, and so that speed was particularly important. In many ways, this was a battle of the experts. The state's expert submitted a report that, with his calculations, Ms. Sexton would have been traveling at least 87 miles per hour at the time of the impact. And the defense expert presented a report that his estimation or his calculation was that Ms. Sexton was traveling between 63 and 75 miles per hour at the time of the impact. That's particularly significant since, although technically this was a 65 mile per hour speed zone, it had only changed, it had gone from 70 to 65, approximately 10 feet from where the accident occurred. So in all respects, this was a 70 mile per hour speed zone. And so under that recklessness element, it would certainly be a big difference if the jury determined that she was going only 5 miles per hour over the speed limit at the time of impact, or if the defense expert was credited as slow as 63 miles per hour or 87 miles per hour. And so the pre-trial, the defense filed a motion to exclude the state's expert testimony based on grounds that it was unreliable pursuant to Rules 702 and 703 and the McDaniel factors. And the basis of that motion was really that the methodology used by the state's expert to calculate Ms. Sexton's speed is an unreliable methodology. He had used what's called a drag sled to calculate the friction coefficient in the case, and that friction coefficient is the number that ultimately forms the foundation for the rest of his calculations. And so just to take a moment to explain the friction coefficient, because it is a foundational number in both the state and the defense experts' calculations. The friction coefficient is just a number that represents the friction between one object and another. And so in this situation, it's the friction between the tires on the vehicles and the pavement on the roadway where the accident occurred. In a traffic accident or in anything in life, when one object comes into contact with another, they exert force against each other, and the amount of force is simply the friction. And so that is a number that, as the accident reconstructionist calculates speed, there's multiple formulas that have to be used to ultimately get to that speed, and essentially they start with plugging in this friction coefficient and then using physics equations to work backwards in many ways to what the speed would have been. And so an accident reconstructionist, although they certainly can gather evidence from the scene of an accident, in this situation, it was the evidence gathered by law enforcement that was then used by both accident reconstructionists to calculate this information. And so specifically the tire marks on the roadway and the length of those tire marks would be indicative of how fast the vehicle was traveling at the time that the brakes were applied. But to get to that speed, the accident reconstructionists need to determine what is the friction between the roadway and the tire, so that then using these equations we can get to the speed number, which is, of course, the relevant number for the jury in this case.
Mr. Cavanis, let me jump ahead just a little bit to get to sort of the crux of the issue. Let's set aside for a moment whether or not the judge commented on the McDaniel factors and considered those, and just look at the underlying reliability of the science. That's really, I think, what the issue is here. As I understand it, the proof was, as your expert was explaining, that the use of the drag sled is no longer considered reliable. And the state's expert said, well, about half the experts find it to be reliable. So wasn't it within the trial court's discretion to determine which of those witnesses he found credible, that he could have found that, well, I believe that it's reliable enough because 50% of them, wasn't that within his discretion to make that determination?
I would agree that, generally speaking, this is a situation where the trial court has wide discretion and we're on an abuse of discretion standard. I think the specific issue with the state's expert statement and whether the trial court did or didn't rely on, well, we know that the trial court did accept that. He accepted that there was a good faith dispute among the experts. But the issue was the amount of, the way that the trial court resolved or didn't resolve the dispute that was squarely before it. And so the evidence that was introduced at this hearing was these two experts, which the trial court found both of them credible. There was no dispute as to that. But then what really tipped the scales was that the peer-reviewed testimony, or the peer-reviewed journals and peer-reviewed treatises were introduced in evidence and presented to the trial court. And these peer-reviewed treatises said unequivocally that that this is not a reliable methodology. This is not a trusted methodology to ultimately determine friction values and speed. And so I acknowledge that the state's expert did say that there was approximately 50-50 debate, but this wasn't a 50-50 debate on application of a method or using one methodology compared to another. The debate was, even if we believe the state's expert, 50% of qualified experts in this field unequivocally are saying do not use this methodology because it's unreliable. But then once we get further into what the trial court actually had before it, the state's expert did say this is 50-50, but none of that was actually presented to the trial court. The state's expert presented one treatise. It was an excerpt from a 1997 report that essentially approved of the use of drag sleds. But then counter to that, the trial court also had a 1990 treatise that the state's expert relied upon, and in that 1990 treatise, the Fricke text, the Fricke, even in 1990, said that this was cautioned against, that there were these concerns about the use of drag sleds because they don't well represent the variables present in a traffic accident. And so that Fricke text was attached in the same report that the state's expert submitted to the trial court. So even by the state's own expert report, there was concern. But then what was presented to the trial court and ultimately never resolved is that the defense presented the more modern 2010 version of that same 1990 text. And by 2010, the text said, do not use these. There was no equivocation about the reliability of this method. The state's own expert also acknowledged that the Society of Automotive Engineers, which the state's own expert again acknowledged is it's a organization that accident reconstructionists rely on their guidelines for the application of their craft. He acknowledged that the SAE said do not use drag sleds, and that was the modern evidence before the court, the modern trend away from the use of drag sleds. And so when we look at what was actually presented before the court, we have these verified, peer-reviewed, and by all accounts, this was not disputed between the state and defense expert. These treatises were from reliable, recognized organizations saying that drag sleds should not be used. And so to the extent that the trial court relied on the state's expert saying, but there's all this other body of knowledge or information supporting the use of drag sleds, none of that was actually before the court. And so I think that's where we fall into the concern about specifically what McDaniel and 702 and 703 talk about, relying on the ipsy-dixy of the expert, that the trial court should not rely on the expert simply stating this is reliable, this is recognized in the field. When there is that concern, as was presented here in this case, the trial court has that additional gatekeeping role and that additional responsibility to delve further into it. And so I think that's the problem, Your Honor, is that although the state's expert said that there was this good faith dispute, none of that was presented before the court other than that 1997 text, which was countered by multiple treatises and multiple organizations presented by the defense, and the trial court just never resolved that. And so I think that, certainly I agree with Your Honor that the issue here is the underlying reliability of the methodology. I think that I would slightly reframe it just to say that the abuse of discretion in this case is that the trial court had these significant conflicts before it and just didn't really resolve them. And so that's where the gatekeeper role was not fully exercised, or not exercised to the degree it should have been. The trial court really just, or fundamentally, I would say, was too relaxed in its gatekeeper role. And we see that specifically in the trial court's ruling at the end of the hearing. It essentially chalked this up to a battle of the experts, or not essentially, that is what the trial court said. This was just a battle of the experts to be resolved by the jury. But then we also see that in how the trial court treated the hearing as the hearing progressed. And so there was a point at which the state began to go into this good faith dispute that the state's expert had alluded to, and the trial court actually interrupted that line of questioning and said that that's all the trial court needed to know was that there is a good faith dispute. And then that was never explored further. There was also a point at which the state's expert had testified that he applied a plus or minus 5% rate of error in his calculations, and he described that rate of error was applied to essentially account for the differences between a drag sled and what those friction values could be in real life or in an actual traffic accident. And then when defense counsel attempted to delve into, well, where does this plus or minus 0.5 even come from, or 5% even come from, the trial court cut that line of questioning off and said this is a trial question. And so those I would say interruptions to the questioning on those key issues reflect that the trial court didn't apply enough scrutiny in its gatekeeper role. I think that those specific issues, is there a good faith dispute and what is it? And then also, how is this methodology being applied? Where does this plus or minus 5% come from? Those are not trial issues at all. I mean, they're certainly relevant at trial, but those are the specific types of issues that need to be addressed in a pretrial hearing. And we see here the trial court just didn't give those enough attention. Those were the issues the trial court needed to resolve at this hearing.
Is this court in the position to be able to make those findings if we find that the trial court failed to do so?
I do believe so, Your Honor, and I think that that's ultimately one point that I would like to make today is that I don't think a ruling in Ms. Sexton's favor, or a ruling that the trial court did abuse its discretion, that's not this court initiating a sea change and declaring that drag sleds are an unreliable methodology. I think that the specific issue in this case is we do have a robust record where there was lengthy pretrial litigation, and these issues were again explored at trial. The treatises that we referenced were introduced, and so the question is really on the record before the trial court, what does that gatekeeper role look like? What do 702 and 703 require when there is this presentation of a significant conflict about the reliability of a methodology before the court? And so there's nothing specific about is a drag sled reliable moving forward. It ultimately comes down to when a trial court is in a position where it has this kind of conflict and this kind of evidence before it, what does that gatekeeper role look like? And so I do believe that this court, if it does find that there's an abuse of discretion, has a record to be able to apply the Daubert-McDaniel factors and make that determination on appeal, Your Honor. And I think we have gotten to the root of the issues. I want to emphasize that what the trial court had before it was that really the state's expert did not dispute the substance of the defense points. The whole reason that a drag sled has been found to be unreliable is that when an accident occurs, there are things like a different vehicle weight on the tires. There are things like heat being applied between the roadway and the tires that impact that friction calculation, and a drag sled just doesn't. A drag sled is a approximately 40-pound tool that doesn't accurately replicate those factors that are present when an automobile accident occurs. And so that's the reason that it's unreliable, and that's the reason that this values table that Mr. Farmer testified about, that's the reason that should be used. And so I want to emphasize that at no point did the state's expert dispute that the treatises introduced by the defense were reliable. He acknowledged that they are peer-reviewed, they are important organizations in the field of accident reconstruction, and he disagreed with the conclusions, but he could never really give a reason why. He acknowledged that all those same variables are present between a drag sled and a traffic accident. He acknowledged that they were present in Ms. Sexton's case. He acknowledged the conclusions of the treatises as far as the calculations go. He just disagreed about whether a drag sled should or should not continue to be used, but he could never really answer that question of why are these treatises and why is Mr. Norris wrong on this account. He just disagreed. And so the trial court was in a position where it should have excluded the evidence, but it certainly should have exercised its gatekeeper role to answer these questions and resolve them at the pretrial hearing. Thank you, Your Honors.
Thank you, Mr. Cavanis. Good afternoon, Ms. Wilbur. Would the state like to be heard?
Good afternoon. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, I'll just confine my argument to the first issue unless this court has any questions on the second two issues, and I'll be happy to answer those. But with respect to the first issue, the trial court did not abuse its discretion when it allowed the state's expert, Mr. Farmer, to testify at trial. What we have is at the pretrial hearing, the court specifically mentions McDaniel, Daubert. He goes and he talks and discusses about the 5 McDaniel factors. He doesn't specifically say, I'm now going through the 5 McDaniel factors, but when you read the hearing transcript, you'll see that he is going through all of the McDaniel factors, and they were all present in this case. And what we have in this case is a legitimate dispute in the scientific community about whether a drag sled produces reliable results. And Mr. Farmer unequivocally testified that it does produce reliable results. He has tested his drag sled results against a Vericom system, test skids, and radar measurements, and he was within 1 to 2 miles per hour of those other methodologies. And he testified that, yes, there is a 50-50 split. With regard, I just want to jump to the Fricke article. It was, I believe, in that 1990 Fricke argument article, he said that drag sleds could be used incorrectly, not that they should not be used at all. So the trial court was in the place of being the gatekeeper to the admissibility of the evidence, not the weight of the evidence. And in this case, Mr. Farmer, the state's expert, testified that a drag sled was reliable. That's McDaniel factor number 1. He said that his attached publication showed that drag sleds yielded acceptable results, McDaniel factor 2. There was a known percentage rate of error, which was plus or minus 5%. That's McDaniel factor 4. And he said, again, 50-50 split on the results of whether a drag sled could yield reasonable results, McDaniel factor 4. And again, he said that he had tested his methods independently of litigation and that his were within 1 to 2 miles per hour of the results from his drag sled results. And again, the question before the court was not which expert are you going to believe? It is, can this expert give the jury an opinion based on facts that will help the trier of fact in their determination? And Scott decision, our Tennessee Supreme Court has said that, again, this is the trial court is being a gatekeeper on the admissibility of the evidence, not the weight of the evidence, and parties can do vigorous cross-examination to show that the other expert is not as good as their expert, and that's exactly what happened in this case. And if this court has no further questions,
I just have one question, Ms. Wilbur. What is required of the trial court when they're looking at the McDaniel factors? To what extent do they need to acknowledge that those factors are there? Do they weigh them? That's
Yes.
what I'm looking for. Is
Yes.
what's required of the trial judge?
Yes, Your Honor. In State v. Copeland, which is a Tennessee Supreme Court case from 2007, the High Court said rigid application of the McDaniel factors is not required. So I think what defense counsel is wanting is saying the trial court must go through every single factor and say, I'm considering this and finding this. I'm considering this and finding this. That is not required. It is required to find whether the witness's qualifications authorize him to give an informed opinion on the subject. And that comes from Davidson, from our Tennessee Supreme Court from 2016. So I hope that answers Your Honor's question. It's
So the
not...
court, I'm apologizing. Please go ahead.
No, Your Honor.
So the court doesn't even have to go through them at all, even acknowledge that they're there. You can just say, like Judge Green said, they're both qualified experts, so I'm going to let it in.
No, I think there is more required, and that is what the trial court in this case did. And you can tell when you read the transcript that he is considering the McDaniel factors, but he did not go, I find this factor, I find this. But you can tell from his line of questioning, and he zoomed in on McDaniel factor number 4, whether a drag sled produces generally reliable test results. So you can see from a reading that he is going through the McDaniel factors, and he is giving them weight and considering, and he does kind of stop questioning a little bit because they're getting off track. And the trial court says, this will dazzle the jury when you do this on cross-examination, but we're here to just determine if this is admissible and not the weight. So when Your Honors read this transcript, you'll see that the trial court did go through the McDaniel factors and did not abuse its discretion when it held that Mr. Farmer could testify as an expert on behalf of the state. If there are no further questions, we ask that you affirm the judgment of the trial court. Thank you.
Ma'am. Mr. Cavanis, rebuttal.
Did not dazzle the jury enough, I suppose. I want to address what I think. I think the state's best argument in this case is to point to Mr. Farmer's testimony that he had personally, independently verified the drag sled results against other accepted methodologies and found them to be consistent. However, again, this is a situation where he testified that he had done that, and then no other information was before the court on that subject. So there was no testimony about the circumstances of that testing, how it was done. He, for example, said that he had used a radar gun. There was no testimony about what kind, when that was completed, and ultimately the important part is how does that verification relate to Ms. Sexton's case in the bigger context of there are international organizations saying that drag sleds should not be used, and so I certainly understand that Dale Farmer's testimony validated that, but there was no explanation or connection between what that conflict was. The trial court just never explored that, and that information wasn't presented to the court. And so,
let me ask you, just out of curiosity, you cross-examined him during this offer of proof?
yes, Your Honor.
You didn't ask him any of these questions?
I would have to rely on the transcript for the order of things, but when I began to ask Mr. Farmer where the plus or minus 5% rate of error came into play, that's when the trial court stopped the cross-examination and said that these were trial questions. And so I can't stand here and say that that's why I did or didn't ask him that, but I will say that there was an attempt to delve further into why he specifically applies a rate of error. Did that, I mean, I don't know where that came from, but I do think that those two subjects are connected about what his testing was, what his findings are related to a drag sled, and how he does his calculations now moving forward. And so just to the extent that that point weighs in favor of the state, and with the McDaniel factors, that this methodology has been independently tested, I would submit to the court that it really, that information just was not present at the hearing, again, particularly in the context of all these other questions that existed. And so I think that's the issue, is that certainly the trial court referenced the correct case, referenced the correct rules, but what I believe should come out of this case, Ms. Sexton's case, is that when the trial court has these issues squarely presented before it, it does need to resolve them. There does need to be that explicit analysis. Certainly if the court had excluded the testimony without any analysis of the Daubert factors, or excuse me, the McDaniel factors, that would be a problem as well. And so with that, we ask that this court exclude or find an abuse of discretion in admitting the expert's testimony and reverse Ms. Sexton's convictions on.
Thank you, Mr. Cavanis. Ms. Wilbur, well done. Appreciate all your hard work. Anybody need a break? We good? All right, Madam Clerk, would you please call our next case?